You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome once again to another edition of Ask a Lawyer here on CP24, where we shatter the myths and misconceptions about workplace rights and how you handle things at work. That's what we do for the next half hour every week. So good to have you here. Joining us, John Scholes, your host, and joining me in just moments here, Chris Justice, courtesy of Sanfilippo Tumarkin LLP, the most positively reviewed law firm in the country, EmploymentLawyer.ca. It's where he's from. That's how you reach out as well. First, the phone number, always right, 1-888-861-4555. And ask@employmentlawyer.ca. That is the email address. We'll get to lots of things on the show, some emails, some phone calls from one of our long-running radio shows, which, by the way, I want to remind you right off the top, Sundays at 1 p.m., News Talk 1010 right here in the GTA. You can catch us doing our radio show for about an hour. All kinds of opportunities for you every week to call into that show, and maybe one of your calls will appear on this show, which we'll get to about 2 or 3 during the course of this half hour as well. But lots of things to get through. 5 common scenarios in the workplace and how to handle them. That is on the way in just a bit, but we always get warmed up on the show with Chris. He's going to give us a bit of a workplace scenario, a week that was, or a case of the day, pal. How are you?
Yeah, thanks for having me as always, John. It's great to be here. You know, as you know, we get inundated with calls each and every day from people from all walks of life with various employment law related issues, whether it's someone looking to have a contract reviewed before signing it, or maybe they've got a problem with their boss during the employment relationship itself, or maybe someone just wondering what severance package is appropriate in their case. But again, it just always goes to show how impactful employment law is on the majority of our lives, and why it's therefore important to understand what your rights, what your options, what your entitlements are. And today I had a case I wanted to talk about that I actually recently resolved. It involved a woman who was an office manager for about 10 years. She had heard through the grapevine at her workplace that another office manager was being hired, and she rightfully was concerned that this might mean the end of her own employment, or perhaps a change to the terms of her employment that she was not on board with. So she got a little bit up in a tussle. She left sort of in a huff, the workplace itself. She was acting very emotionally. She sort of did it in the heat of the moment. She collected her personal belongings, again, fearful of the worst, and stormed out of the workplace. She then returned a few days later, the next week, to essentially apologize to her employer, to explain the situation, and to essentially say that she was ready to come back to work, that she had a bit of a cooling off period over the weekend, and only to find that her employer said that they had apparently accepted her quote-unquote resignation, and told her that they weren't going to give her anything, that her days with the company were over, at which point she then phoned me up and wanted to know, what her rights, what her entitlements are. And after talking with her, I quickly realized actually that this is not a resignation at all. As many of us know, resignations need to be clear and unequivocal, and they need to be expressed to the employer quite clearly. And in this case, the employer sort of inferred on the basis of her actions that there was a resignation without actually making any further inquiry into it. And not to mention that, but also there was a relatively short period of time that had passed before she came back. So the employer didn't actually take any steps to replace this woman. There was no prejudice suffered on the employer's part. And in these types of cases, when considering all these facts, again, I quickly realized that a resignation had not happened, and that employer actually had the duty to have her come back, or otherwise be viewed as having terminated that woman, for which they would owe her a significant amount of severance. Now, in this woman's case, fortunately, she wanted to go back. We were able to negotiate with her employer to get them to understand that she was to return, and that's exactly what happened. But it could have very well been the case that the employer simply did not want to have her back, in which case, as a 10-year senior office manager, she could have been looking at anywhere from 14 to 16 months of severance. But I thought this was important because I know a lot of people may be saying things or doing things in the heat of the moment and think, I'm dead to rights, I don't have a leg to stand on anymore, when actually you have rights, you have options, and you need to seek legal advice before communicating further.
All right, as I mentioned off the top, EmploymentLawyer.ca, that is the website you want to go to. Among other things, find a radio show close to you that carries our show. You can always reach out as well, 1-888-861-4555, ask@EmploymentLawyer.ca. News Talk 1010, right here, Sundays at 1 p.m. You'll catch our radio show. Let's get to our first phone call from the previous show. We'll talk about it right now.
A friend of mine, she just got terminated from her workforce. The reason was due to economic conditions. We're currently realigning our workforce with new business goals. Now, they said that they're giving her 5 weeks notice and you will receive 2 weeks of severance. Now, she's worked there for 6 years. She's in electronics, 41. And they also never paid her any holiday pay for any of the years that she took holiday. Is she legally entitled to holiday pay as well as more severance than that?
Okay. What do you think?
Yeah, so there's two situations here. First, the holiday pay. Employers obviously have to give their employees holiday time off, statutory holidays, and if the employees work those days or otherwise, they have to pay holiday pay. So if you're in a situation where you've maybe recently discovered that your employer hasn't been paying you statutory holiday pay, then you have the ability to actually go back over all those years and recoup that amount of money. So that's number one off the bat. Number two, with respect to her severance, as many of us know, anytime someone's offered a severance package, it's often going to be far below what they're actually entitled to. And if we can turn to the Employment Law Pocket Employment Lawyer Board, we can kind of see here the stats of this particular individual. So as they said, they were there for about 6 years. They were offered 7 weeks, and they're in a technical role. And as you can see at the very bottom there, you see the potential severance owed. And you can understand just how different maybe someone's bare minimum obligations are or rights are under the employment legislation versus what their full common law severance rights are. So this is a classic example of a situation where this person needs to give us a call. They need to contact us both with respect to the holiday pay issue, but also in order to secure that full severance package.
All right, good start. We'll take a short break. As Chris showed you right there, the severance calculator can be found at pocketemploymentlawyer.ca, but you can always reach out by phone, right? 1-888-861-4555 and ask at employmentlawyer.ca. 5 common scenarios you're going to find in the workplace and how to handle them, how to tackle them. We'll tackle that after a short break right here on Ask a Lawyer, CP24. Hang on.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back. Thank you so much for hanging in. This is Ask a Lawyer here on CP24. John Scholes here alongside Chris Justice from EmploymentLawyer.ca. Want to reach out? You can anytime. Always encouraged to make that phone call. Have a chat on your own time, right? 1-888-861-4555. Ask at EmploymentLawyer.ca. Chris, you're loving this topic for today, pal. It is 5 common workplace scenarios and how to handle them. These are all absolute beauties. This is under the marker of big bull or wrong, every one of these things. The first one is this. Your boss says they had a legitimate reason to let you go. Therefore, well, they don't owe you any severance pay.
Yeah, you hear this a lot. Employers are just simply mistaken. You know, it's one thing to have a legitimate reason for letting someone go. And for the most part, as long as the termination's happening on a without cause basis, employers can let you go for essentially whatever reason they want, with, of course, the caveat being it can't be discrimination. It can't be some instance of egregious bad faith. But other than that, they can let you go. But the key thing is if they're going to do that, they have to pay you severance. And so for an employer to say that they don't have to pay you severance, alarm bells are going off. That means that they're trying to assert what's known as just cause. And that bar to meet just cause is very high. It's very difficult. It's very rare that employers will actually have just cause to terminate someone's employment. So if you're being told that you're not owed any severance, think again, because there's a high likelihood that you are owed severance and possibly a large amount of severance. Now, when these situations happen, someone's first instinct might be to go to the Ministry of Labor. I caution you to do that because if you do go that route, you may only be able to secure your bare minimum rights and not your full common law severance rights. And you won't necessarily be able to go back after that happens, after you file the complaint with the ministry to get your full rights. So be cautious before doing that, seek some legal advice. But otherwise, absolutely, these cases very rarely end up in a cause termination.
All right, scenario number 2, your employer tells you that they're transferring many of your duties to a new employee because, well, they're younger and have a fresher look.
Yeah, sort of a roundabout way of saying, we think you're too old, or, you know, again, alarm bells are going off. I'm thinking if there's any part of the reason why this change is happening to this employee's situation has to do with their age, that is a clear violation of human rights code, and they're entitled to damages on top of any severance entitlements. And I say that because in this case, when there is a significant change imposed on your employment, you need, first of all, to raise objections so you have a record on it, because otherwise you're going to be seen as having condoned that. But if you object to it and your employer insists on imposing those changes, that can amount to a constructive dismissal at law, which will entitle you to the same full severance package as though you were let go.
5 common workplace scenarios, how to handle them. Number 3 is right now you're ready to return to work from a disability leave with modified duties, mind you. But your boss says, yeah, you know what, it's time to find yourself a job elsewhere. Bye-bye.
Yeah, terrible decision, you know, a clear instance of failure to accommodate. And again, if any reason for the failure to accommodate had to do with the fact that this person was off on a medical leave of absence and is now seeking modifications to come back, the employer again is in hot water. They're exposed to human rights damages, not to mention the fact that failing to accommodate when you have that duty as an employer is going to also trigger termination rights. So again, another instance where an employer is in extreme hot water.
All right, Chris, number 4, and again, this one very common. Your employer puts you on what they call a performance improvement plan, but that is unattainable, impossible to satisfy, right?
Yeah, I've got so many of these cases, unfortunately, where the goals that are set are so high that it's just impossible to achieve. And then the employer is going to try and rely on that later on to justify a termination. First of all, to have a just cause termination based on someone's performance, extremely hard to do. The employee almost has to be going out of their way to perform poorly. And so short of that, it's always going to be a without cause termination, even if they are trying to paper their trail with these performance improvement plans. Now, a key thing with these plans is you've got to object to the criticisms. You've got to state very clearly that the goals are unattainable. Otherwise, again, you're going to be seen as potentially having condoned the plan, maybe agreed to the plan, and later on won't be able to push back as much in your fight for that full severance package.
Let's get to our 5th and final one of the common workplace scenarios that are how to handle. We're going to get you in some hot water. This one's got alarm bells written all over it, Chris. Says your boss wants to sign a new contract, have you sign a new employment contract, and threatens to penalize you if you don't sign it.
Yeah, first of all, the threat of penalizing someone if they don't sign it, I mean, that can be viewed certainly as a reprisal, as retaliation, and again, put that employer in hot water. But anytime you are in an employment situation and your employer is asking you to sign something different or new, or frankly, even if you're going into an employment situation, your employer is asking you to sign something, you got to have that reviewed by a lawyer first. You got to make sure you understand actually what's in the contract, because you could be giving away rights that amount to tens of thousands, if not more dollars and cents. So you want to make sure that you understand what you're signing, because also there's got to be consideration going both ways. Anytime an employer wants you to sign something for its benefit, there needs to be a reciprocating benefit on your end so that you get something. But these are just some of the main factors to consider.
We're going to send you back to EmploymentLawyer.ca. Again, there anytime to find a radio station or radio show near you, pretty much across the country, right here in the GTA, as a matter of fact. It'll be Sundays at 1 p.m. on News Talk 1010. You'll catch Leora, Chris, and myself doing the show. Let's grab another phone call from the radio show, talk about it a little bit.
I was working for an employer. We were bought out by a company, and they wanted to close down the location that I was working at and move everybody to a new location. It was a good distance away. I went from about a 20-minute drive to about an hour and 15 minutes. I was just wondering, does the employer have to compensate their employees for moving to the new location, or is that kind of considered a way of a dismissal as well?
Question.
Yeah, so I mean, it's one thing for the move to maybe add 5 or 10 minutes onto somebody's commute, but it's an entirely different thing to add this much time. And I mentioned earlier the phrase constructive dismissal when there's been a significant change to the terms of someone's employment. And this also includes terms relating to how long it takes you, relating to your commute. And so adding this amount of time, especially when you factor in over the course of the full day, you're adding upwards of an hour or 2 more onto someone's day. That's going to normally constitute a constructive dismissal for which you're going to be entitled to severance. So there are also possibilities that you could negotiate something with your employer to sweeten the pot so that you might end up accepting a change like that. But if that's not going to happen, again, that's going to be a significant change, and you're going to at least have the option to walk away and treat your employment as having been let go.
Loving the phone calls. Want to get to one more on the other side of the break, so we'll do that. But to reach out to Chris anytime, pick up that phone and call 1-888-861-4555. You can also email. That is simply ask@employmentlawyer.ca. This is Ask a Lawyer. Continues right here on CP24. Hang on.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back. We're here. Ask a Lawyer on CP24. John Scholes, Chris Justice from EmploymentLawyer.ca. Always able to reach out. You are 1-888-861-4555. Ask at EmploymentLawyer.ca is the email address as well. And EmploymentLawyer.ca, the website, is where I keep telling you to go to find a radio station in your region where you can catch our weekly radio shows, including Sundays at 1 p.m. right here in the GTA on News Talk 1010. Let's get to phone call number 3 and talk about it a bit.
I have a situation.
Okay.
I'm 71-year-old. I worked for this retail store for 6.5 years, and they're closing the store, and they're giving me 11 weeks pay.
What do you think?
Yeah, so short of that company actually filing for bankruptcy protection or creditor protection, a lot of people have this mistaken belief that because somebody's storefront is closing or a part of the operations are closing, that therefore somehow not entitled to severance or maybe less, when that just simply isn't the case. You know, this particular individual is still going to be entitled to their full severance rights, unless, as I say, there's some sort of bankruptcy issue or insolvency issue. But it could also be the case that just this particular store is closing and not the entire operation as well, which is a very different thing. So I think given this guy's statistics, how long he's been there and his age, he's looking at a pretty healthy severance package if we want to actually flip to the Pocket Employment Lawyer board right there. And there you go. On the screen, you can see it in terms of, again, someone being offered something that is a big far cry away from what their full rights are, and just more the reason why people need to be cautious when they're offered severance packages, no matter what the context is, whether the company says they say they're going out of business or that's not the case. Either way, you're going to be looking at a substantial amount more of severance, and you definitely don't want to sign anything before first getting some legal advice.
And by the way, you have free and anonymous access to that severance calculator through PocketEmploymentLawyer.ca, like Chris said. I want to get to an email, pal, we got some time here. It says, I signed a 1-year contract with my employer. However, they ended my position early by 10 months. Am I entitled to anything? It was my 3rd contract in a row with the company.
Yeah, so there's a couple of different ways this can play out. For example, you can start a job for the first time, a year-long contract, and only maybe be in a month or 2 into the contract itself and get let go, and actually be entitled to the full balance of the contract. Whereas normally, you might only be looking at a few months. In that particular scenario, the balance of the contract could be 8, 9, 10, 11 months. There's also a situation that can happen where an employee is signed up to a number of fixed-term contracts over the years, and it just becomes so frequent that it's almost like an automatic renewal. And the employer will often times try to attempt to say that this is an employee who at all times only had 1 year or less of employment, and yet they've been signing successive contract year after year after year. Well, they're going to be seen as an employee in that circumstance, and they're going to also potentially be owed full common law rights, even if the latest contract they have expires. So, as I say, it can play out a number of different ways, but either way, you're often looking at much more severance, of course, than the employer is willing to offer.
Got a few minutes to go. We'll take a short break and back to more. In the meantime, that number again, 1-888-861-4555 and ask at EmploymentLawyer.ca. This is Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer here on CP24. John Scholes here, Chris Justice alongside from EmploymentLawyer.ca. You can reach out, always can, no problem. 1-888-861-4555. Ask at EmploymentLawyer.ca. Let's get to another question here, Chris, with our last couple minutes. It says, I've been on long-term disability from mental illness for nearly 2 years. My doctor says I still need 3 months before going back to work, but the insurance company just told me that they can't be certain my employer will hold my job for that long. Can they force me back to work like that? What do you think?
Yeah, no, I mean, absolutely not. The trump card here is the doctor. You know, this employee's physician, this employee's treatment providers, they're going to basically trump both the employer and the insurance company as long as they're providing necessary support and advising as to reasonable accommodations, or maybe advising that the person should stay off on a leave. In this particular case, the individual, you know, obviously needs a bit more time before they can come back. And the employer knows this, and yet it's essentially saying that it's not willing to accommodate, or at least that's the word. And that's going to be considered a failure to accommodate, of course, especially when you've been told that, you know, it's only going to be another few months before they can essentially return back to full-time duties. And, you know, on the insurer side, a lot of people worry that, you know, at that 2-year mark, they get cut off.
Yep.
They think, am I going to get any more disability benefits? Am I entitled to anything? Well, unfortunately, far too often insurance companies will cut people off after the 2-year mark. But generally speaking, that doesn't mean that they're not still entitled to LTD benefits, and it's just something they may have to fight with the insurance company on. But going back to the employer, if that's what the doctors are saying, the employer's got the duty to accommodate. And if they don't want to do that, even if there's some undue some burden or inconvenience on them, it's not going to be enough for them to just say, we don't want it, we want to have you come back right away. They're going to be in hot water, as we discussed earlier on the show. Human rights damages potentially, severance damages potentially, and then that person's going to be left potentially also having another battle on the LTD side.
And that duty to accommodate is a pretty high threshold. They have to step up and do that, right?
Yeah, again, there's really got to be undue hardship shown on the employer's side, and that's going to depend on the size of the employer. That's going to depend on what accommodations are being asked for. But in my experience, the vast majority of accommodations, the vast majority of modification requests are reasonable, and the employer just simply doesn't want to suffer that inconvenience. You know, even if the employer has to spend some money or incur some cost to accommodate this individual, that is still going to be expected of them, and it's not going to be enough to say there's undue hardship for that reason. So yes, absolutely, the employer's got that duty. Otherwise, again, they're in really hot water.
All right, brother, always good stuff, and that is just about time for us. Again, I'll give you the contact information as we roll out of here for another show. To reach out to Chris and his team, 1-888-861-4555. That email we always go to is ask@employmentlawyer.ca or simply employmentlawyer.ca, the website. And for that severance calculator, it's free for you to use. Millions of Canadians have used it. pocketemploymentlawyer.ca. And a reminder to catch our radio show right here, News Talk 1010 in the GTA, Sundays at 1 p.m. And please come back, join us for another edition of Ask a Lawyer here on CP24. We'll catch you next time.